The methods for getting the divorce, the filing procedures, what is filed in the circuit court, what we call the initial document, the initial paper that is filed is a petition. I think that reference has already been made to that, but there is a petition that is filed by the husband or the wife, whoever is proceeding with the divorce, and that petition has to be sworn to under oath. It has to state that there is an irreconcilable breakdown or an irretrievable breakdown of the marriage, and it has to state certain factual information. For example, the parties' ages and their occupations and where they live, the date of the marriage and where the marriage is registered, the date of the separation, whether the wife is pregnant, and the names, ages, and addresses of any living minor children of the parties. If custody is involved, it must also state where the children have resided for the last 5 years and whether the person filing has participated in any other custody litigation or knows of another person who claims to have custody rights. Finally, the petition should state what it is the person seeks. If they seek the divorce, and that is it, then that is what is sought. Typically, the divorce petition will state that the divorce is sought, that if children are involved, whether the person seeks custody, the support, whether the person seeks alimony, and if the person is seeking court costs or attorney's fees. The other spouse, the non-filing party, then must file an answer. That must be done within 20 days from the date that the petition is served upon them by the sheriff or through the mail, certified mail. As with the petition, that answer should be sworn to under oath before a notary public, and it should be filed within 20 days after service of the petition. If it is not filed within 20 days after service of the petition, then the other party may proceed with the divorce without the non-filing party having the benefit of all of the rules of court. Now, I should state that in this particular circuit, that is Carroll, Owen, and Grand County, the courts afford the non-filing party a little bit more protection than is normally afforded under the Kentucky Rules of Procedure. That is, under the current local rules, even though the non-filing party may not file that response within 20 days, and they are technically in default, what we call in default, the person moving ahead with the divorce must still notify that party of the hearing date or the upcoming hearing that is taking place in the court. Finally, if this non-filing party is in the military service and this materially affects his or her ability to appear, that person may delay the action under a federal law known commonly as the Soldiers and Sailors Civil Relief Act. The question then on what happens next depends upon whether or not the action is a contested divorce or an uncontested divorce. If it is contested, then the case will normally proceed through the courts with the presentation of proof by calling witnesses who would be sworn under oath and answer questions and be cross-examined. There may also be expert testimony presented as far as the value of certain property, for example, an appraisal of the home. And the court must hear all the issues, and if there are children involved, that will also there will also be evidence presented or testimony presented concerning the best interest of the child, whether they should be placed in the custody of the husband or the wife, and what visitation should be allowed. Also, as has already been touched on, matters concerning child support, and basically everything that that has been presented to you today will come up in the contested divorce. If it is uncontested, which is often the case, a property settlement agreement or a separation agreement, basically a written agreement between the parties, will address all of these issues and will reconcile them based upon the parties' agreement. This agreement, however, must be approved by the court. If it does not involve issues concerning children, then the question is whether or not the agreement is unconscionable or so unfair, manifestly unfair or inequitable. If the court determines that the agreement is unconscionable, then the agreement will not be approved. However, it should be remembered that simply because an agreement is what we call a bad bargain, that will not cause the agreement to be rendered unconscionable. Secondly, if there are children in the marriage, there is another consideration, and that is any agreement concerning in whose custody the children will be placed, the amount of the support, the visitation terms, any of the issues concerning the children. The court must also consider whether or not the agreement between the husband and wife is in the child's or children's best interest. And that must be determined by the court in order for the agreement to pass with the court's approval. Finally, one matter that is of concern, whether it is a matter, something that is sought in the petition, the court cost and attorney's fees, or whether it is a matter to be discussed or agreed upon in the separation agreement. How do the parties divide the cost and attorney's fees, or what does the court do with the cost and attorney's fees? First, I should say that the court costs are the costs involved with filing the divorce petition. Before the circuit court clerk will accept that petition as filed, the court costs, the filing costs, must be paid into the court. Typically, that is in the neighborhood of $85 at the present time. If the person is to be served by a sheriff, then there is presently a $10 charge in addition to that, which must be paid to the sheriff. The other costs that typically are associated with the divorce proceedings are expert witnesses who may be testifying as to the appraisal values. There will be a fee or a cost associated with either having them testify in court or having their deposition taken. And if their deposition is taken, then a court reporter will charge a fee for having that done, and that is an additional cost. The attorney's fees are basically just what the person would normally think of them, and that is the fees directly associated with representing the husband or wife in the divorce action. The parties can, in the separation agreement or in that property settlement agreement, agree as to how the court cost and attorney's fees will be divided between them, or whether or not one person will have all of those costs for themselves. If the agreement is not reached, then the court will determine if the costs are to be apportioned or divided between the parties and how. Generally, this is considered by the court after looking at the general financial resources and ability of each person to bear those costs and fees. I think that about covers the nuts and bolts proceedings, and hope that this tape will help you in the future as if the unfortunate situation should arise where you are presented with a divorce situation.